Hello everyone, welcome to StudyIQ IS English channel. I am your educator Praveen Mishra and continuing the subject, the series of Indian polity, we are now into the fifth class, that is the fundamental rights. That is what we are going to start today. Okay, so in the previous sessions we have discussed about the Constituent Assembly, the preamble and the salient features of the Indian Constitution. And now we are moving on to the very next one, that is the fundamental rights of the Indian citizens. So before entering into the chapter, okay, let's just understand the meaning of these two basic terms that we call it as fundamental rights. The basic two words here, okay. How do I define the word rights? What are rights? What is the actual meaning? So, an individual's legal claim towards something. Legal claim towards something. In layman term, we can call it as rights. Okay? When you have got a statute, a law supporting you towards something, that particular claim is known as right. Now, when we talk about the word fundamental, how do I define this word fundamental? So, the word fundamental basically means natural. And the word natural basically means basic. So simply speaking, whatever is fundamental, that is natural, or whatever is natural, that is basic. Let's reverse this, going into the reciprocal thing. Whatever is basic is natural, or whatever is natural is fundamental. So I can call it the fundamental rights, the natural rights, or the basic rights of an individual. They are all same, right? Okay. So that is rights that I do possess by being the virtue of a human. That is what basically fundamental rights, the basic rights or the natural rights. Given to me by nature itself. That is, you might have heard that statement, right? We come to this globe, we come to this world bare hands, and we do go back from this world bare hands. खाली हाथ आए थे हम खाली हाथ जाएंगे. No. Political science, the discipline, the study of political science doesn't accept this statement. Absolutely not. What political science says, okay, what is the correct statement here? That along with my mind and body, heart and soul, I am born with my fundamental rights as well. I have born with it and I will go back from this world with my fundamental rights. That means no one can give it to me and no one can take it away from me as well. So fundamental rights, they do basically create the base. Base of what? The base of the civil society. This is what the genesis of fundamental rights they are. Okay. So what the chapter has to teach us. I hope the fonts are visible. It's not being too reflecting, okay, with the camera lights. Okay. So, fundamental rights in the Indian Constitution are essential human rights that apply to all citizens regardless of the factors, who they are, from where they are, okay, whatsoever they are. It is given to each and every Indian citizen, okay, regardless of their religion, caste, gender, place of birth, place of residence, profession, etc., etc. Okay. Then these rights are legally enforceable through the courts, although there are some conditions, okay, that is reasonable restrictions that we have also discussed in the previous class. Next, they serve as a crucial role in promoting political democracy by establishing the doctrine of limited government. So basically, fundamental rights, they impose restrictions, and restrictions on whom? On government, basically. Okay. Next big thing. The main purpose behind providing these fundamental rights to citizens is to prevent the government from enacting arbitrary laws to safeguard the liberties and freedom of individuals. Okay, so simply the overarching rule of the fundamental rights, they are to establish the rule of law rather than the rule of men. Okay, so this is what the basic definition with fundamental rights. Okay, and now coming it in the more advanced way. So, as we were discussing about the sources of the Indian Constitution, the very next chapter, okay, that is the second or the third class, I think, of the series of the polity. In that, we have discussed about the Bill of Rights, that is written or enshrined in the American Constitution. Okay, so the concept of fundamental rights in India has been inspired from where? The United States Bill of Rights. These rights, as you can see, are crucial part of the Constitution because they are seen as a vital for the development of every individual's personality. As in the preamble chapter, we were discussing about liberty. What is this word liberty? It tells about the constraints. There is no constraints on an individual's growth and development. Each and every individual is free to grow himself or herself according to their will and choice, obviously not breaching the law, not breaching the margins of the human society. Okay. Next big thing here, the part 3 of the Indian Constitution, commonly known as the Magna Carta of the Indian Constitution, contains elaborate provisions regarding fundamental rights. So, as we discussed in the salient features of the Constitution, Constitution comprises of nearly 25 parts, from part 1 to 25, going with alphanumeric sense. In there, we have got part 3 from articles 12 to 35 that talks about what? Simply the fundamental rights. Okay, so what we have called fundamental right is the word that you need to mark as what? Magna Carta. What is Magna Carta? Magna Carta is simply the most important element of something. That is Magna Carta. Okay, like for example, for a vehicle, what is the Magna Carta? Fuel. Whatsoever the vehicle is, as luxury as you want, it can be, but it is useless until and unless you have a fuel in it. So, for our society, for our constitution, the fuel, that is the Magna Carta, is part 3 from articles 12 to 35, that is the fundamental rights. So they are termed fundamental because they can be legally enforced. This means that individuals can seek court of court in case of violation of any of the rights. So simply speaking, fundamental rights, Magna Carta, and yes, they are legally enforceable in case there is any violation. Okay, you guys can approach the judiciary as well for the sake of its resettlement. Okay. So guys, here is the thing that if you guys would like to connect with me over my social media handles, so please do. If you want to connect with me over my Telegram, so it will be study_with_Praveen. So basically just go on the search bar and type study with Praveen and you will be directed towards my Telegram channel. Or if you want to connect with me over my Instagram, so here it is, the handle Praveen Mishra _2107. Okay guys, so wherever you guys want to connect with me, you guys can connect and discuss all of your doubts related to your academics and preparation, and any notes if you want me to send you, so you can connect with me and for sure I'll share it with you. Okay everyone, so moving to the next point here, the features of fundamental rights: justiciable and enforceable by courts. In case of their violation, if any of your fundamental right is breached, any of it, then you have got the authority, the permit, to directly approach the judiciary. You can breach the hierarchy. If you want to directly go to the Supreme Court, you directly go to the Supreme Court. Like in general cases, what happened? Firstly, you'll have to appeal to the subordinate courts. And the judgment, after the judgment has been passed by the subordinate courts, in case you're not happy, then you can appeal to the next big one, that is the higher court. And in case the judgment has been passed by the higher court as well, and you are not even happy with that, then you can approach directly to the apex court, that is in case of India, Supreme Court. Okay. But for general cases, in case of fundamental rights, breach or violation or abrogation of any kind of your fundamental rights, then you can breach this hierarchy of subordinate court and high court. You can directly appeal to the Supreme Court of India under Article 32. Or let's say you don't want to go to Supreme Court, then under Article 226 of the Indian Constitution, you can directly go to the concerned High Court. Okay, whatever your state is. Next big feature, not absolute, subject to reasonable restrictions. Are fundamental rights absolute? Are fundamental rights divine and sacrosanct? No. They are subject to reasonable restrictions. See, in order to let society be society only, in order to have the word civil along with society, that is civil society, it is important to give the individuals all the liberties and the freedoms they want. But on the very contrary side, it is also important to keep a check or a margin or a cap on the individual's freedom. Because in case there is no margin, there is no boundary, there is no capping on the liberties, then that one particular individual could eat out or could eliminate or vanish the whole society, as what the dictators they do. What's the name with Saddam Hussein, or what's the name with Kim Jong Un and him both? What's the name with Idi Amin, or what's the name with any other dictator whatsoever, like for example Adolf Hitler, right? So these were the guys with no capping on their powers, no capping on their freedom. And what they did is always seen as an horrendous and egregious act in the books of history. So that is why each and every fundamental right of every individual comes with some reasonable restrictions. Okay, that is in order to maintain public order, morality, just balancing the health of the masses, the nation, the planet as a whole. Some reasonable restrictions are always kept on each and every individual's rights. The next thing here that we need to discuss, are they subject to amendment by the Parliament? Does Parliament of India under Article 368 possess the power to amend any fundamental rights? Yes, they do have it. The Parliament, while exercising its rights, its power, its authorities under Article 368, can amend fundamental right, but they do have to keep this thing in mind, that their authority is not breaching the doctrine of basic structure of the Constitution. So there could be existing multiple doubts in your mind so far that we do not have any clear insights or clear vision over what is doctrine of basic structure or what is this doctrine of reasonable restrictions. So relax, guys. There is nothing to worry about. Okay. Very soon, okay, after this session only, there will be another video uploaded over our same StudyIQ English channel, where I will be decoding in a very short span of time. It won't take much longer. I guess it should be not more than 4 or 5 minutes of the video. Okay, where we will be discussing about doctrine of basic structure, doctrine of reasonable restrictions, and every day we will be having a separate series where we will be discussing about the important doctrines related to our Indian Constitution, as well as the cases related to the Indian political machineries as well as the Constitution. Okay, guys, so stay tuned and relax. Do not worry about anything. There will be no problem. Okay, that's what the assurity what we can give. Okay, so coming to the point, the doctrine of basic structure and the doctrine of reasonable restrictions, they are both, so that will be discussed. So amendable by the Parliament under circumstances, and what are those circumstances certain? That is covered under the doctrine of basic structure. Okay, so the next big thing here, the fundamental rights, they apply to all persons, with certain rights reserved for citizens only. Okay, so that is, most of the rights apply universally to all of us, to all of the humans, but there are some certain fundamental rights that are given only to Indian citizens and not the aliens, that is the foreigners. That is, like for example, Article 15, 16, 19, 29 and 30 are specifically reserved for the Indian citizens only. Okay, then apart from that, it provides the protection against the arbitrary action of the state. So fundamental rights, they act as a check on the power of the state, okay, and providing citizens a perfect safeguard against the arbitrary or unfair government action. See, the genesis of democracy is what? It works exactly on the opposite pages or on the opposite lines of monarchy. East and West, North and South, these are the two political philosophies which are poles apart, right? So democracy was given the existence just in order to curtail the atrocities that the masses they do experience or encounter in a monarchy rule. Okay, so the existence of democracy is just on the opposite sides of monarchy. In a monarchy, the people they do not have any rights, or even they do have, it is subject to the wills, choices, wishes, conditions of the ruler itself, right? So in a democracy, fundamental rights are considered negative for the state, that is for the government, as it restricts the government from taking any sort of actions which are troubling for the masses, their growth and development, their ease of living as well as livelihood. So, in general, in layman's term, what we can state here, fundamental rights are positive for the citizens, whereas they are negative for the state. Why so? Because fundamental rights, they do provide the freedom to the citizens, whereas the fundamental rights only, they do provide restrictions to the state, that is to the government, from doing anything they want. Okay, so simply speaking, they do provide check on the power of the state, providing citizens a safeguard against the arbitrary or unfair government action. Okay, next big thing here. Foundational to judicial review. As if you have seen that particular session that where we were discussing about the PILs and the establishment of welfare state in India, we have discussed this segment in detail. So guys, I request you all, if you haven't watched that video, please go into the channel's video section, okay, and you will just scroll down a bit. You will be encountering or witnessing a video titled as the PILs and the welfare state in India. Okay, the establishment of welfare state basically. Okay, so please do watch that video as well. We have discussed in detail the judicial review concept. Started in the year 1803 or 1809 if I'm not mistaken, in America, in a very famous case of Madison versus Mulberry, where judiciary of America stated that any laws that are inconsistent with the fundamental rights of the citizens, they shall be considered immediately unconstitutional. And from there, the evolution of the doctrine of judicial review started. Okay, so the rights that are given to the citizens, they should be never hampered, and in case the government or the state has enacted any statute that is troubling, disturbing, or interfering with the rights of the masses, then the judiciary has the right to review that particular law and declare it as unconstitutional, that is null and void, that is simply nullified. Okay, so this is what the fundamental rights, they also do provide the foundation stone for something that is known as judicial review. Okay, so now coming here with the next figure, the key categories of the fundamental rights in India, how they are categorized. The fundamental rights, they are given a stratification, or an umbrella terms are used for some sort of fundamental rights. Okay, that is, they are divided in different groups. Like for example, we have got the right to equality, and the grouping is from Article 14 till Article 18. Then we have got right to freedom. The grouping comes between Article 19 to 22. Then we have got right against exploitation, Article 23 and 24. The right to freedom of religion from Article 25 to Article 28. Then we have got right, cultural and educational rights for minorities, specifically Articles 29 and 30. And then we have got the last group with just one article in it, that is right to constitutional remedies, that is Article 32. And now, a question that would be roaming in your cerebral hemisphere here. Sir, just in the beginning of the session, you stated Part 3 of the Indian Constitution comes from Articles 12 to Article 35. But here, the grouping starts with Article 14 and it ends basically at Article 32. Why so? Yes, it is just the grouping, or even not an official grouping. This is not a grouping that is done by the Constitution. There is no grouping done inside the Constitution. It is simply starts Part 3, Article 12, and it ends with Article 35. This is what, with our understanding, we have grouped it. though it is not officially done by the Constitution. So guys, remember, there is no official grouping inside our Constitution. Okay. So starting with Article 12, that is the definition of state. See guys, from today onwards, today altogether onwards, I would just like to provide a disclaimer. What's the disclaimer? That while reading Constitution, just make this thing very clear in your mind that for each and every word from today onwards, for each and every word, there exists two distinct definitions. One is the general definition for any word that you can see over your dictionary or Google, wherever. The other definition is the constitutional definition. Very high possible chances that what is the general definition of a word could also be the same definition in the Constitution, but there are chances as well. What the definition is generally could not be the same definition constitutionally. So make this thing clear in your mind that from today onwards, what you have in your mind, that is the general definition. Okay, that is also, but for the very same word, there exists now another parallel universe, that is the constitutional universe. And for it, the definition could vary, could be similar as well. There could be similarity and could not be as well. So be very specific, be very real, okay, while understanding the figures, the facts, the words, the phrases, the statements of the Constitution. Once again, at last, I would like to quote, could be same with the general definition, could not be same as well. Okay, so here comes Article 12, definition of state. Well, English has been often criticized of being a foolish language, right? Though a very not so ethical statement to give, but many scholars of literature, they have stated English to be a foolish language. Why so? One word, multi definitions. Multi definitions, right? SON, son, is the child as well as the heir. Okay. Like, for example, there are many things. Okay. Like SUN, son, is also pronounced, but son is not neither the son nor the son. Okay. So in that very same case, when it comes to state, the aspirants, all of the candidates, they have got big confusion over this word state. State means that their state, Uttar Pradesh, Andhra Pradesh, Arunachal Pradesh, Gujarat, Kashmir, Tamil Nadu, and these are the states only. Okay, yeah, that is also the definition of state. So, state, one definition of state could be unit of a country. Like, yes, from the Indian context, UP, Tamil Nadu, Andhra Pradesh, etc. State, another thing is, another word, another definition for state also, you know it very well, that is condition. That I'm in a good state, okay, I'm in that state, I'm in this state, etc., etc. Then, state is a phrase, is a term also used for country. The synonyms of country is a state as well as nation. Okay. So this is how state, yeah, state is here also one thing, that is to speak. Okay, that is simply to speak, from where the word comes statement. So one word, multi definitions. And what is state according to the Indian Constitution? What are the things as the Constitution of India identifies that they are state? How can I define that this is the state, that is the state? Okay. So as what we can see, the word state according to Indian Constitution, Article 12, Part 3, includes the following. That is, the government and the Parliament of India. They are inducted in the definition of state. The government and legislature of each and every state that is the unit of a country. The local authority, for example, the panchayats, the municipalities. Other authorities, that is, for example, okay, it could be organization. Like, for example, okay, we can keep the example as the DRDO, Defense Research and Development Organization, ISRO, Indian Space Research Organization, Bhabha Atomic Research Center, or the Life Insurance Corporation. Okay, they are also coming in the definition of state. Why? Because one thing that you need to add here, okay, is this. How do I define this word state according to the Constitution? That is, according to Article 12. Simply speaking, all those territories, or let's say boundaries, organizations, or it could be institutions, governed directly or indirectly by Government of India or by any state government will come under the definition of state. Okay, will come under what? The definition of state according to the Indian Constitution. Okay, guys, so be very specific the notes that you are making. All the territories, or let's say boundaries, organizations, institutions which are governed directly by the government of India, or maybe indirectly by the government of India, or government of any state, directly or indirectly whatsoever, those all territories, organizations, boundaries, etc., whatsoever, they will be considered as a state itself. And hence, now watch out for this definition. So, the government and the Parliament of India, the government and the legislature of each state, local authorities including corporations, panchayats, municipalities and so on, they are the definition of state. Other authorities within India or under government control, by defining state broadly, fundamental rights are enforceable. Okay, so by defining broadly, fundamental rights are enforceable against various bodies responsible for governance. Okay, so this is what simply the definition of state is. And according to this definition, Jammu and Kashmir, Ladakh is also a state. It's a union territory. Yes, do not get confused. It's a union territory, tagged as a union territory. But does it come under the definition of state? Yes, as it is a territory directly governed by the government of India, tagged as a union territory. Will DRDO come under the definition of state? Yes, why not? Because it is governed directly by government of India. Same goes with State Bank of India, Reserve Bank of India, or any nationalized bank, or maybe any private bank as well, as they are also indirectly governed by the government of India through the RBI. Okay, we have got the Life Insurance Corporation, any colleges, schools that are governed by the governments. Okay, they will also come under the definition of state only, right? Okay, so state here, not that unit of state, Andhra Pradesh, Uttar Pradesh, Bihar, Madhya Pradesh, or Maharashtra, Karnataka, Kerala, Andhra. No, state here as in the territory which is governed by government of India as well as any state government. Okay, so this is what the general definition of state comes in. The next definition, Article 13. What is Article 13? Definition of law. In general, what is law? In general definition, a set of rules and regulations that are bound to be followed, and in case of violation of the law, an individual is always subject to punishment, right? This is what basically law is, right? But what are the things identified by the Constitution as law? Okay, general definition is correct. Okay, fine. That is a set of rules or regulations, okay, that are bound to be followed, okay? And in case of violation of the rules or the laws, then the individual is subject to the punishment as well. Yes, absolutely, that's a true concept. But now the question is, what are the things identified by the Constitution as law? Okay, so the acts passed by the Parliament, so as simple as that, what we can keep here. So Article 13, that is definition of law. Okay, so how do we define? Here we go. First one, acts passed by Parliament. Next, acts passed by the state legislature, that is the state parliament. Ordinances issued by President under Article 123, or ordinances issued by governors of the states under Article 213. Then orders, judgments, or decrees passed by judiciary, they will be all considered under the definition of law. And one more thing, any order or let's say notifications issued by gazetted government officer, gazetted government officer, will be inducted in what? In the definition of law. Okay, so Article 13, what is the law? Any act passed by Parliament, any act passed by state legislative assemblies, simply the state legislature or the state parliaments, ordinances issued by the President in case the Parliament is not in session. Then in that case, if there is any need of any specific law which is not in existence, then using Article 123, President can promulgate or issue the ordinances. Same goes inside the states, the governors of the states, when the state legislative assembly is not in the session and there comes the need of any law which is not existing, then using Article 213, governors of the states can pass or promulgate ordinances. Apart from that, any orders, judgment or decrees issued by the judiciary from subordinate courts to high courts to Supreme Court, okay, they will be also considered as law. And last but not the least, the gazetted government officers, that is class 1, grade A, those who have got the Gazette of India, when they issue any order or any like notification, then also it shall be considered as an law only, as a law only. Like for example, with the last line here, I can give you a very realistic example that you might have experienced it in your school life. So during rainy days, rainy season, it might have happened with you multiple times that in the morning you woke up, though in a very reluctant note, but yes, you have to get ready for school, and suddenly you get to see it's raining heavily outside, and suddenly there comes a message that the schools are closed today throughout the city or the district even, as the order has been issued by the Honorable District Magistrate. Okay, and he has or she has declared the day as rainy day. Right? So that rainy day order is passed by a gazetted government officer. And that gazetted government officer's order shall also be concluded as law. Okay? So in that day, if the district magistrate has issued the orders to declare the day as rainy day and close the schools and colleges, no school, whatsoever the school is, whosoever that school belongs to, cannot be running that day. In that case, the school authorities, they breach the order issued by the district magistrate. The district magistrate can proceed legally and can, take any legal action against the school or college if the school or college is running on the rainy day, declared rainy day. So guys, this is where the definition of law comes in. So I hope everything is clear. Okay, so as what we can see, the doctrine of judicial review, according to Article 13, Clause 2, is also explicitly taken from the Article 13, Clause 2 also, that is judicial review. Okay, so the doctrine of judicial review, Article 13 empowers, Article 13, Clause 2, you can just mention here, Article 13, Clause 2, empowers the judiciary to review the laws declared to review the laws and declare any law that contravene fundamental rights as invalid, null and void, simply unconstitutional. Okay, so this is what the judiciary holds the power with any existing law, any pre-constitutional laws, any upcoming laws, anything. Okay, so this is what Article 13, definition of law. And next big thing into the picture, Article 14, that is equality before law and equal protection of the laws. Let's be very specific. Article 14, what does it actually states? What does it actually talks about? Article 14 says equality before law. That is, we all the citizens, maybe citizens or even not the citizens, that is the foreigners, we are all equal in the eyes of law. Big or small, rich or poor, ugly or handsome or beautiful, doesn't matter. Law treats each and every individual citizen equally. It's written in the rule book, that is Constitution. Let's not be so realistic. So Article 14, equality before law. Each and every individual, that is rich or poor, ugly or beautiful or whatsoever, is equal in the eyes of law. Okay? It has got two parameters: equality before law and equal protection of laws. So let's discuss the difference between the two. Equality before law, what it says. And what is the concept of equal protection of laws? Equality before law is firstly considered negative in nature, whereas equal protection of laws is a phenomena that is considered positive in nature. Okay? Why negative in nature? Because it says that no person will be given special treatment. Okay, it refrains any sort of special or advanced treatment towards an individual. Whereas equal protection of law, what this states? This states that every person will be given special treatment. Now you can understand how the policy or the program or the scheme of reservation in India is justified. See, we're not discussing whether reservation is right or wrong, needed or not needed. That's a matter of big, lengthy debate, and forget it. We're discussing about the constitutional validity of reservations in India. Okay, how are they valid? Because if we follow the provisions of equality before law, it simply states no person will be given special treatment. And yes, undoubtedly, reservation is a special treatment. That means India follows the other part of the equality law. Simply speaking, every person will be given special treatment. Now you will be thinking about, ki sir, reservation is justified or given to a section of communities only, not all of the communities. Okay, so let's just eliminate this thing as well. In India, those who are considered as general. So this is the general community. And there is another community that is here that is not general. Simply speaking, it is a community that has undergone colonial exploitation, and before that, the non-colonial exploitation as well. That is lower caste citizens. Though the word even lower caste, I do not want to take, but it is the tag mentioned everywhere. So unfortunately, we have to. Okay. So there is a general community and there is a non-general community. That is a community which has undergone absolute level of exploitation. Okay. Simply speaking, now they are considered as scheduled community. So these are the communities which have faced absolute immense amount of exploitation, grave violence, subjugation, and discrimination at its heights. Okay. So the general community is said to be already specially treated, whereas not the non-general or the scheduled or the community which has been exploited a lot. So the general word itself hides this word itself, okay, with himself, okay, that is special. But here there is no hidden term that is known as special. So when I follow the equal protection of laws and I want to give special treatment to everyone, so general community is already specially treated. Now the special treatment to the scheduled communities will come in the name of reservation, with the help of which they can just eliminate this lower line and enter into the mainstream community of the nation. So that is what this is considered as a ladder. Okay, so we can simply call it a ladder given to the non-general community. Okay, so that they can, with the help of this ladder, climb above and come into the mainstream society line. And what is the name of this ladder? The name of the ladder is reservation. See, reservation in itself is the discrimination. No doubt in that. But there are two types of discrimination. The first one is considered positive discrimination and another one is considered negative discrimination. So negative discrimination is for the sake of exploiting or subjugating someone. Okay, it comes for the sake of exploitation, domination, or simply subjugation. But the positive discrimination, where it comes from? What is this positive discrimination? It is for the sake of upliftment. Okay, this is for the sake of upliftment or the growth plus development. So is reservation discrimination? Yes, but it is on the positive note of discrimination. Okay, so reservation is what? Yes, in itself it is a discrimination to those who are getting it, also to those who are not getting it. But it's a sort of a positive, not sort of a, actually a positive discrimination. Okay, so what policy we follow in India with regard to Article 14, equality before law? It is the equal protection of laws. That simply ensures that all individuals are treated equally under the law, and it prohibits actually the arbitrary discrimination by the state. There was a very famous political scientist or a philosopher or a theorist, we can call him as, okay, that is the name A.V. Dicey. A.V. Dicey. Okay, he propounded the theory that is named as here we can understand. A.V. Dicey. He gave the theory that is something known as rule of law. Okay, what is the name of the theory? Rule of law. It should be law who should be ruling the nation, not the men, not the humans. Who should be the source of the law? The source of the law should be the masses, that is the citizens. As we were discussing in the yesterday's chapter itself, that is preamble, the very first line of our preamble, we the people of India. So the we the people of India is what? The source of power, the source of authority. And we have decided to establish a society based on the constitution, simply following the principles of constitutionalism, okay, which derives its authority from the rule. Rule of whom? Rule of simply the law. That is, law is supreme. No one is over and above the law. And what law sees everyone as? Law sees everyone as equal. Okay? Everyone will be considered equal. Okay? So this is what Article 14. The theory still Article 14 they are. So guys, I hope you have got the clear insights over the basic definition of fundamental rights and the meaning, the definitions from Article 12, 13 as well as 14. And if there is existing any doubt in your mind, then you are free to ask it, okay, immediately without any questions. And apart from that, if there is anything you are facing, any difficulty you are facing, then for sure you can just connect with me, okay, over my social media handles here, okay, so that we can have a proper discussion over it. And guys, please do subscribe for the channel if you haven't done yet, and do like the video as well, as your support is mandatory for us. Okay, so the channel handles, okay, they are here. In Instagram it is as Praveen Mishra _2107, or you can also connect with me over my Telegram, that is Study with Praveen. Just do not forget to use the underscore there, so study underscore with underscore Praveen. Okay, so you can connect with either of the handles wherever you are comfortable, and let me know if there is any doubt related to academics are there. Okay guys, so for today, this is the session with regard to the introduction to the fundamental rights. We have discussed about the basic meaning, definition of the fundamental rights, and apart from that, the three articles, that is Article 12, 13 and 14. So we'll go slow and steady, and we shall be just going in as much as depth and analysis as we can have. Okay guys, thank you so much. See you all soon in the very next session. Bye bye, take care, good night, Jai Hind.